The afternoon session of the Judicial and Bar Council with respect to the candidates for the vacancy in the Supreme Court Associate Justice is now open. Please take your seats. I am standing in for the Chief Justice. Please do not worry. I will not vote. The first to ask questions is the Honorable Judge Monteverde of the Judicial and Bar Council. Yes, Your Honor. You have to swear. Okay. Go ahead. Clerk of Court will swear them in.
With your permission, Your Honors, the candidates for interview this afternoon are the following: Justice Oscar V. Badelleles, Justice Apolinario D. Bruselas Jr., Justice Edgardo L. de los Santos, and Justice Eduardo B. Peralta Jr. May I request you to please raise your right hand so that I can administer the oath? Do you swear to tell the truth, the whole truth, and nothing but the truth in this public panel interview by the Judicial and Bar Council? So help you God. You may now be seated.
I now call on the Honorable Judge Monteverde.
Thank you, Justice Leonen. Good afternoon. Okay, scanning over your health record, Judge Badelleles. While physically fit, yet your medical exams, such as the blood chemistry and blood count, shows that you have high results.
That is correct, Your Honor. That was the time when I changed my medicines, Your Honor, because I was having discomfort with my previous medicine, so there was some adjustment. That's why the chemistry spiked up, Your Honor, at the time.
But despite that, that result, you are still fit to physically and mentally
fit,
to discharge
yes,
the duties of your office.
I take a walk 30 minutes every day. Then on weekends, if possible, I play golf.
Okay. Now, if appointed to the Supreme Court, what do you think will be the biggest adjustment you will be facing, coming, of course, from the Court of Appeals, that you have been there for 6 years, and what challenges do you foresee if appointed?
I believe the questions that are presented or the issues presented before the Supreme Court are much different from those presented before the Court of Appeals, because the Court of Appeals is a trier of facts, Your Honor. And so that adjustment, because the issues now before the Supreme Court are more focused on the constitutionality or validity of certain acts or decisions, Your Honor.
You have been in Cagayan de Oro for so many years already?
Yes, almost 7 years, Your Honor.
7 years.
Yes.
Now, what are the advantages and disadvantages of being assigned there as Associate Justice of the Court of Appeals?
The reason I refuse to be assigned here in Manila, Your Honor, is convenience, actually, because I am from Iligan, and it is very convenient for me to go home every weekend. And the cost of living in Cagayan de Oro is much lower than cost of living here in Manila, Your Honor.
Okay. What is your view on the divorce bill that has just been filed?
Well, personally, Your Honor, I believe that marriage should, as much as possible, be preserved by the government. However, to my mind, Your Honor, that divorce bill merely confirms certain situations where the family or the marriage has already broken down irreparably. So that when that divorce is brought, petition for divorce is brought before a court, what we see is a broken family. And no amount of, I don't know, counseling might bring them back together. In fact, in some families, they go to the extent of killing and injuring each other, harming each other. So, to my mind, the divorce bill is good as to certain families or certain marriages which have already broken down beyond repair. But as a rule, as a general rule, we should strive to preserve the family, Your Honor, as the basic unit of our society.
Now, how different is divorce from a petition to declare a marriage a nullity?
I really have not read the bill, Your Honor, the proposed bill on divorce.
Yeah, assuming that it passes through.
I would assume, I'm just speculating, Your Honor.
Yeah, your personal view.
There are similarities, Your Honor. I believe that, but in divorce, the grounds for divorce may be different from declaration of nullity of marriage, where perhaps, like as I said, there is a complete incompatibility between the husband and the wife. They have been fighting, and their family is broken. Their attempt on the life of one against the other, those may be the grounds for divorce, Your Honor. But as to annulment, I understand that annulment would be more on the legal side, Your Honor, that, for instance, the consent has been vitiated, the authority of the person solemnizing is not present, among others, Your Honor.
How about psychological incapacity?
Well,
That's a ground for granting the petition to declare a marriage a nullity.
yes, Your Honor, that is one of the grounds under the present law, Your Honor. But as I said, the grounds that might be in the proposed divorce law might be different, Your Honor, other than psychological incapacity.
Justice de los Santos.
Yes, Your Honor.
As it is, the power to appoint judges and justices of the Court of Appeal of the court is lodged before the President. There are, however, some proponents who seek to remove from the President the authority to name the members of the Judiciary, and instead transfer the same to the members of the Supreme Court themselves, who are supposedly in a better position to choose the incoming members of the Judiciary. What is your opinion on this matter?
If you're referring to the appointment of the members of the Honorable Supreme Court, Your Honor, I also agree that that is an ideal setup, because the choice of the members of the Supreme Court is being made by people who are really eligible as to the competence of the aspirants based from their performance as members of the integrated bar. However, we have to take into consideration that the present practice is in observance of the principle of separation of powers and checks and balances, because the present setup, the President, in appointing the members of the Supreme Court, is exercising checks and balances. While, as I've said, it is an ideal setup, because the members of the Supreme Court are, as I've said, more eligible as to the qualifications, how they perform as members of the Integrated Bar of the Philippines, and if they have been trial court judges or appellate court justices, they know how they perform while they were in office. So these people are better equipped, more qualified to choose, and there is less politics or even no politics at all in the appointment of the members of the Supreme Court.
Justice Peralta.
Good afternoon, Your Honor.
My question is this. Justice Leonen, as the next bar examination chairman, proposed to follow a pass-or-fail only system. He also wanted to make it possible to hold the bar examinations in various areas. Are you in favor of Justice Leonen's suggestions?
Regarding the proposal to consider the passing of the bar examinations only to a rating of pass or fail, I tend to agree with Justice Leonen regarding this matter. Perhaps the intention there is to avoid the possible scenario where there is this usual problem among law schools as to which garnered the most number of top-notchers. Perhaps that is the idea of Justice Leonen there. So I tend to quite agree with him.
Okay. Thank you. You were appointed RTC judge in Branch 17 in Manila and appointed Associate Justice in 2010. But from 2007-2014, you were also a professor in Angeles University. Is that correct?
Yes, Your Honor, if my memory serves me right, of 2010, if I'm not mistaken, Your Honor.
But
Up
you
to
were already a
2013.
justice of the Court of Appeals, and how can you shuttle from one area to another?
Yes, Your Honor. In 2010, when I was initially appointed to the CA, my first assignment was in Cebu. And I was there for about 2.5 years. And then I shuttled from Cebu to Manila and vice
Cebu?
versa. Cebu, yes, Your Honor.
Okay.
And then every Monday and Wednesday, because I have to be here in the Supreme Court every Thursday and Friday, for the meeting of the subcommittee on the rules on criminal procedure. That is the usual schedule that we have. And then for Saturday, we have this shuttle from Manila to Angeles for the Angeles University Foundation, my teaching. So by Monday, I'm back to Cebu already.
If appointed to the Supreme Court, what reforms would you want to initiate in the Philippine bar exams?
Regarding the format of the bar exams, I intend to respectfully submit that it can be composed of essay writing as well as multiple choice questions. I understand there is a proposal for somewhat a lowering of the percentage with respect to the type of questions to be posed to the examinees, in the sense that there would now be more essay type questions, if I understand it correctly. But on my point of view, I respectfully submit that it would be best really to focus on the essay writing skill of the examinee rather than focus on more multiple type questions. I do concede that these multiple type questions can accelerate the checking of the booklets, but I also submit that the responsiveness or the ability of the examinee to expound on the answer can best be addressed by the essay type questions, Your Honor.
Thank you. Justice Bruselas, your blood chemistry, FBS, and HbA1c was quite high during your last blood chemistry exam tests. Is that correct?
That is correct, Your Honor.
Are you a diabetic?
I'm diabetic, Your Honor. That's correct. But it's controlled, Your Honor.
How
Type 2
controlled
diabetes.
is it?
Well, controlled in the sense that it doesn't go beyond the maximum, this
But
7.8.
7.8. But
That's
that's
go beyond
that's the borderline.
The range, yes, that's correct, Your borderline. My doctors tell
But
me,
the HbA1c shows otherwise.
I think it's still below 8, Your Honor. It's 7.6 something.
Oh.
My doctors tell me, both the private physician and the government physician, they tell me that these are not worrisome numbers, so long as over time they don't spike up above 7.8 or something.
So this does not affect your performance.
So far, Your Honor, it does not affect my performance, Your Honor. To be very truthful about it, I've been able to produce as much as is needed, Your Honor.
I'm asking this question because one of the candidates yesterday said that he is not his fit. While the blood sugar is high, but still it's under control. And then later on, in a few minutes, somebody gave him some candies.
I have not had that episode, Your Honor.
Okay.
Do
So you
not
don't
require-
take insulin shots.
I don't take insulin shots, Your Honor. I have maintenance medicines, but not insulin shots. I hope it doesn't graduate that insulin shot, but my doctors tell me that not to worry because my previous history shows a controlled experience.
Okay. So can you differentiate judicial legislation from judicial restraint?
Well, as a matter of principle, judges, judiciary is not supposed to do any legislation. Legislation, rulemaking is the core competence of those in Congress, the political organ of government, other than the presidency, you know. So when we talk of judicial legislation, we are simply talking about the Supreme Court in particular, deciding a case, and in the process of decision making, they somehow traverse into making a particular rule for that particular case. We call that judicial legislation, but we do not really legislate. Now, judicial restraint is a sort of a philosophical outlook on the part of justices, that say that they should, as much as possible, refrain from interfering in what? In matters of policy, economic policy, matters of national security, matters that are not their core competence. So you restrain yourself. We call to mind the old political question doctrine, which is, in a nutshell, tells us that when a question is political in nature, it's best for the court to restrain itself. But of course, we know that in our Constitution, that philosophy has more or less been diluted because we now have in the Constitution the power of judicial review, which amongst others, apart from saying that the power of judicial review is the power of the court, which includes the matter of settling actual cases and controversies involving rights that are legally demanded and enforceable, also include the courts determining whether or not an agency or instrumentality of government has exercised discretion, has gravely abused discretion. That's the other way. That's what I'm saying now. The political theory, more or less, political question, political policy, so to speak, that courts should refrain, more or less tells the court now that you should, in proper cases, look at what is the policy. But as I said, better for the courts to restrain itself from going into these things unless very, very necessary.
How composed are you when you discuss things with somebody?
The judges do not usually interact with many people.
Your co-judges
Well, even in the Court of Appeals, we have cubicles
and
there.
justices. Correct. I'm sorry. With justices.
Yes. Even in the Court of Appeals, Your Honors, we do not have much time to socialize other than there are birthdays or other occasions. In other words, we are pretty much left to ourselves. And the only time when we are able to discuss is when we have deliberations. So for example, I'm a chair of the 7th Division. I meet my division members every 2 weeks. So it's the only time that we are able to interact.
You
and
don't get
decide.
excited or
Well, sometimes there is trigger for excitement, but generally we are composed. We decide on cases on the basis of what are the facts.
you don't get irritated?
So I have not gotten irritated to the point that I shout. Not at all, Your Honor. What I do experience is that when there are many thoughts racing to be brought out, I somehow tend to speak very, very fast. When there are competing thoughts in my mind, trying to get themselves out of my mind, I tend to speak very fast. So that is a weakness probably on my part. That's why I try to slow down. And
I'm asking this question because you are a diabetic.
yes,
And diabetics have a tendency to get irritated.
that is correct, Your Honor. There are many judges who, as part of the moment, just would shout indication of being diabetic. But fortunately, Your Honor, I have not had that kind of episode.
Okay, thank you. In international law, what is the doctrine of unilateral binding declaration of heads of state, and how is it applied? Justice Peralta?
There is perhaps a corollary principle in international law which can equate this principle which Your Honor mentioned. And I'm talking about the concept of pacta sunt servanda, in the sense that contracts must be complied with in good faith, subject to the rule on rebus sic stantibus, in the sense that there can be deviation from the pacta sunt servanda if there is a change in the situation of the parties which would render execution inequitable or unfair, perhaps. I submit, Your Honor.
You. Justice De Los Santos, what long-term programs do you want to initiate in the Judiciary, in the Supreme Court, if appointed as an Associate Justice?
Perhaps, Your Honor, I would introduce some amendments in the internal rules of the Honorable Supreme Court. Like, for instance, providing some timelines in the performance of certain functions from the time that a complaint or a case is filed and received at the receiving section. Perhaps there is a need to state a certain period when the case file will be moved to another department up to the time when the case is delivered to the justice in charge or the ponente of the case. Because I have noticed, Your Honor, I have read the internal rules of the Honorable Supreme Court. There are, I think, only 3, if not 2, where there are some timelines. Like, for instance, when the rolio should be, I think, submitted to the clerk of court or to the division clerk of court. And other things that once the Supreme Court has, the Honorable Supreme Court has issued with finality a decision or promulgated a decision, I would suggest that copies of the decision should immediately be furnished or to the other members of the Honorable Supreme Court to avoid conflicting decisions. In other words, the other members of the Supreme Court will be immediately furnished copies of the decisions just promulgated. And also, when the records of this case will be returned to the lower courts, the judge should immediately be furnished a copy also of the decisions, especially when it comes to reversal, not just the office of the clerk of court. The same thing is true when it comes to appellate courts. The Honorable Supreme Court should not only furnish the office of the clerk of court, the assistant clerk of court, copies of the decisions, but also furnish the ponente, especially in cases where the decisions are reversed. And if it is not to be done that way, perhaps state there's an express directive to the assistant clerk of court to have it machine copied and furnish the ponente of that decision. As far as the lower courts are concerned, I would suggest that since one of the evils that we sought to be avoided is the congestion of court dockets, perhaps the Honorable Supreme Court can see to it that there will be more judges, more courts. And as to particular court personnel, I suggest that court stenographers, the position of court stenographers and court interpreters should be made coterminous with the term of the presiding judge, because it has been my experience. I have been a trial judge for about 37 years before I was appointed in the Court of Appeals. I noticed that most of the court stenographers are relatives or close family friends, and very few in the whole Philippines know how to use the steno machine. And they don't really know their work as court stenographers, and it adds to the congestion of court dockets, the inefficiency of the court stenographers. Going also to the position of court interpreters, most of our court interpreters, or rather court legal researchers, most of our court legal researchers are either low graduates or have not passed the bar, and they're just contented as court legal researchers, but they are not actually of big help to the presiding judge. So I suggest that these two positions should be made as coterminous with the term of the presiding judge.
Okay, thank you. Now, prior to your appointment as an associate judge in the Court of Appeals, you were assigned in Bacolod for 15 years.
Yes, Your
Is that
Honor.
correct?
Almost 16 years, Your Honor.
Okay. What was your greatest accomplishment and contribution there as an RTC judge?
It may sound self-serving, Your Honor, but
Just go ahead.
I think
We will listen.
yes, I think my reputation there, even among the people from the media, is that I am a no-nonsense judge. I imposed death sentences before. I was assigned not only in Bacolod but in other courts in Negros Occidental. I usually handled, if not three cases, or rather three salas at the same time. So I'm known to be workaholic. Most of the time, I stayed in my office in the Hall of Justice. I went home at 10, 11 o'clock in the evening. At 5 o'clock in the morning, I'm already in my office because my family is based in Dumaguete. And I think I am perhaps the only judge during the time when I was assigned more than 3 cases regularly. I have to travel the whole Negros Island, from Negros Occidental to Negros Island to Gihulngan in Negros Oriental.
Okay.
So I was really overworked, and I was even known to be a hanging judge because of my propensity. Perhaps I don't know whether the term propensity is appropriate, because I did not hesitate to impose capital punishment or the death sentence, Your Honor.
So you don't agree with to revive the death penalty?
I am in favor of reviving the death penalty, Your Honor. In one case that I decided while I was an RTC judge of Bacolod.
Just give you reasons.
Yes, because for me, aside from the fact that the imposition of the death penalty is the right of a state as in the nature of self-defense, there are really some ruthless criminals, and we have to take into consideration the rights of the greater majority of the people, the innocent civilians, because that would be in accordance with what we call common good, the greatest good for the greater number. There are more innocent civilians who should deserve peace and order, and there are few offenders, criminals, especially those who commit heinous crimes. So the rights of these criminals should be balanced with the rights of the other citizens of the country.
How about you, Justice BADELLES? Are you in favor of the death penalty?
Yes, Your Honor, because I believe that one of the functions of death penalty is retribution, Your Honor. It is the right of the state to demand retribution from the person who has committed heinous crimes, Your Honor. And
Yes,
moreover,
continue.
not all convicts, Your Honor, are capable of reformation.
Now tell us the doctrine of constitutional supremacy.
Constitutional supremacy, as I understand it, Your Honor, is the power of the Supreme Court or the Judiciary to determine and allocate the various powers between the three branches of government in accordance with the provisions of the Constitution. So that in the end, the Supreme Court or the Judiciary is not dictating on the the other branches of government, but rather simply stating for a fact how these powers of government were allocated among them, the three branches, Your Honor.
Justice PERALTA, what is your opinion on the death penalty? Do you favor it?
Regarding the prospect of imposing anew the death penalty, I am inclined to restrict it in accord with constitutional prescription only with respect to heinous crimes. So for any other offenses outside, I am in favor of the death penalty, if ever it will be reimposed, only for heinous crimes.
And what are those heinous crimes?
The Constitution is silent as to the scope of heinous crimes. But to my recollection, there is Republic Act 7659, which enumerated the heinous crimes such as treason in Article 114 of the Revised Penal Code, kidnapping, I think, if my memory serves me right. But in general, the heinous crime is limited to those which are odious, Your Honor.
When we had the death penalty before, heinous crimes was defined in it. But considering that we now don't have the death penalty, so we don't have a definition for heinous crimes. Is that correct?
I would like to believe, Your Honor, that if my memory serves me right, there was a jurisprudence regarding the scope of a heinous crime. And the Supreme Court defined it in that way, in the sense that the crime, if odious or so, what do you call this, transcends the usual concept of a felony, then it would amount to a heinous crime as specified by law.
Okay. Justice Bruselas.
Yes, Your Honor. If I may add to that.
Yes.
7659, as quoted by Justice Peralta, is actually the heinous crimes law. And under that 7659, RA 7659, there is a definition. Well, we do not have to have a qualitative definition, but there is a provision there which says that those offenses punishable by death are heinous crimes. And so
Now, what are the heinous crimes?
Yes, these are those punishable by death. So it's, but in the Supreme Court's interpretation of that, if the penalty is perpetual to death, those are heinous crimes. What are these? Treason, as mentioned by Justice Peralta, qualified piracy, qualified bribery, plunder, kidnapping for ransom, um, dangerous drugs violations punishable by perpetual to death. This is about 20 crimes enumerated with that penalty, perpetual to death. So that therefore, if we are asked, what is a heinous crime? Then we say, a heinous crime is one that is penalized by perpetual to death. It's difficult to say one that is odious or a great, because it's qualitative. So we go by what the law says. One that is penalized by perpetual to death is a heinous crime.
Yes, but what are the heinous crimes?
That's what I said.
What?
The 7659 is specified.
What are those?
Well, as
You don't remember?
I said treason, Your Honor,
Oh,
under
one.
114. Qualified piracy.
Okay.
Qualified bribery. The special law 7080, plunder law. We have kidnapping for ransom. Okay, that's a crime against liberty. We have dangerous drugs acts violation, punishable by perpetual to death. We have arson. We have carnapping, where
Rapes.
yes, carnapping, rape, where death results, no? Because not all rape are punishable by perpetual to death. So only those crimes which are penalized by the penalty of perpetual to death, those are heinous crimes, as stated under RA 7659. So therefore, those convicts who have been convicted under that would therefore be convicted for heinous crimes. And they will not be available, they will not be able to invoke the allowances, additional allowances provided for by RA 10592.
Now let's go to another topic. Justice Badeles. Sogi or Sogi bill is now one of the favorite topics social media. No? How important is religious belief in discussing these LGBT plus issues in general? Because remember that in the hearing there were nuns attending it. So how important is religious belief in this issue?
In what case, I remember, Your Honor, the Supreme Court has decided, I think that's Ladlad versus Comelec, that religious belief should not be a basis for classification, Your Honor. In like manner that sexual preference of this SOGI, this LGBTQ, Your Honor, cannot serve as basis for their classification. As far as I can see, or as I'm concerned, Your Honor, they do not constitute a class. They do not constitute a class by themselves, because what they are espousing or promoting is that sexual preference. That is not their gender. It's more of their sexual preference. Some prefer, the lesbians prefer women. The gays prefer men. It's sexual preference. It's not gender.
How about transgenders wanting to use the women's or the ladies' room, such as what happened weeks ago?
To my mind, Your Honor, maybe a special facility can be built for them, but generally they should follow the gender that they are born with. So if they are born male,
They should go to the men's room,
yes, Your Honor.
even though they are transgenders. All right.
Yes, Your Honor.
Your view on
Because,
this, Justice De Los Santos?
Your Honor, if I may be allowed to make a suggestion or for us to make a solution for that problem, I think the ideal thing is that there should be a restroom for the male, a restroom for the female, then a restroom for the transgender or trans woman. But if the government thinks that it is more expensive, I think it would be better if it will be based on the physiological features of that person using the restroom. If he is male or even called transgender, he can use the male restroom, because I think there have been no news or reports of these people being really discriminated or being humiliated while using the men's restroom. And whereas if they're going to be allowed to use the female restroom, we are still in a country where not so as liberal as the Western countries. Our women would still feel uncomfortable if men, although dressed in a female dress, they still feel uncomfortable being with them. I respect the rights of the LGBT community, and I even believe that this SUGI, there is it's a substantial classification. They belong to a class. The rights should be recognized. The rights should be protected so long as these rights will not affect the rights of the majority, like the women and the youth.
Thank you.
Thank you, Your Honor.
Justice Bruselas,
Your Honor, please.
you were shortlisted for Associate Justice post for 9 years, 9 times already.
That is correct to my recollection, Your Honor.
Okay.
Please.
Why
And
do
I'm
you
very
think you
thankful.
didn't make it in those instances? And do you feel that today is the best time for you?
Well, I hope I can share your optimism, and I'd like to believe that today is the moment. But to answer your question, Your Honor, about why have I not been appointed out of the shortlist 9 times? Well, it's really not up to this representation, Your Honor. It's the President's call as to who he wants to appoint. It's just that the JBC should be able to give him a list from which he can select anyone to be in the Supreme Court. It is unfortunate that it has taken this long, 9 times of shortlisting, and I have not been given the opportunity. But I share your optimism, Your Honor, but that today, this may be the moment, Your Honor. And I am very thankful for the JBC for continuously reiterating my name as part of the shortlisted aspirants. I hope that I will not fail the expectations of me, Your Honor. Thank you very much.
Okay, this is my last questions for all of you, and this is common. Justice Peralta, convince us why we should vote for you.
Regarding the applicants, Your Honor, I have a high regard for the other applicants, but I respectfully submit that perhaps what can be considered a good point insofar as I am concerned is the incremental pursuit of knowledge on my part. Because after passing the bar, I pursued further studies. In 2005, I was the first graduate of the San Beda Graduate School of Law. And thereafter, I persisted further by pursuing a doctorate degree in another university. So I would suppose, modesty aside, my record can perhaps speak for themselves, and my stint also with the RTC as well as the MTC of Manila can perhaps persuade the distinguished members of the council as to why I can also be considered as a possible candidate in that list. Your Honor.
Justice Badeles,
Same question, Your Honor.
same question.
I submit that I can make a difference if I make it to the Supreme Court. On the ground that I have shown in my track record as RTC judge and as Court of Appeals judge that I can deliver, make decisions. In fact, when I left my RTC station, Your Honor, I left only around 50 cases. I did not go lower because my colleague advised me not to. Otherwise, the Supreme Court will assign me to give me other additional assignments. Now, in the Court of Appeals, Your Honor, I can say with pride, Your Honor, that I have only, the last time, Your Honor, I have only 98 cases for completion. I have no case submitted for decision, Your Honor. So with that track record, Your Honor, I believe that I can make a contribution, I can make a difference if ever I am appointed to the Supreme Court.
Same question, Justice Bruselas.
Thank you, Your Honor. I have spent 36 years, Your Honors, of law practice, and of 36 years, 33 years of them have been in the criminal justice system, 3 years in the Justice Advocate General Service in the Armed Forces as a regular officer, 8 years as a public prosecutor in Rizal and Makati, and then another 8 years in the Regional Trial Court of Quezon City, and then 14 years in the Court of Appeals. I also had 3 years in the private sector before that. And I mean, given the, in all humility, Your Honor, given the wealth of experience that I have undergone, my view is that this wealth of experience would be able to help me in contributing to the Supreme Court, Your Honor. Amongst the aspirants, nominees, Your Honor, I believe I'm the only one with a national security perspective. And from that point, probably I can, that is a nuance that I can probably contribute to the court, my experience in the national security sector earlier, Your Honor. That is all.
Same question.
Same question, Your Honor. If you'll allow me, Your Honor, after passing the bar exams and signed the roll of attorneys on April 21, 1978, a week after that, I joined the government as court legal researcher of the Court of First Instance of Manila. Then 2 years after, I was employed as technical assistant and later court confidential attorney to one of the honorable justices of the Supreme Court, who later on became a Chief Justice. Then after that, I was appointed a municipal judge. I was there for 4 years. Then an MTCC judge for 6 years. In a total of 10 years as first level court judge. Then I was appointed RTC judge. I stayed there for almost 16 years. And in addition to that, I had multiple assignments. After that's 10 plus 15, that's about 25 years. I am now a Court of Appeals Justice for 11 years in Cebu. So I think my experience, all my life, I devoted all my life, professional life, in the judiciary. And I think my experience, the number of years I've been working in the government and only in the judiciary, has given me enough wisdom to perform the functions of a member of the Honorable Supreme Court. The wisdom and experience are my qualifications, Your Honor.
That was my last question. Good day and good luck to you.
Thank you, Your Honor.
Thank you, Judge Monteverde. With the permission of my colleagues, I would like to just interject a few questions. That is all right with my colleagues. Justice Peralta, the Section 4, Paragraph 1 of Article 8 of the Constitution, would you remember what Article 8 of the Constitution is?
This is about the judiciary,
Yes.
Your Honor.
Okay,
If I'm not
Paragraph
mistaken.
1, Section 4 states, the Supreme Court shall be composed of a Chief Justice and 14 Associate Justices. You remember?
Yes, Your Honor.
And Section 9 of Article 8 provides, the members of the Supreme Court and judges of lower court shall be appointed by the President from a list of at least 3 nominees prepared by the Judicial and Bar Council. Let me repeat that. Section 9 states, the members of the Supreme Court and judges of lower court shall be appointed by the President from a list of at least 3 nominees prepared by the Judicial and Bar Council for every vacancy. Now, supposing that there is a member of the public, a lawyer, that files an action for prohibition against the Judicial and Bar Council from continuing with the election or the shortlisting of 3 nominees for the position of Chief Justice, on the theory that Section 9 states the members of the Supreme Court shall be appointed by the President from a list of at least 3 nominees, etc. Her contention is that the Chief Justice, like the Senate President and the Speaker of the House, appears to be or should be selected from among the 15, and the 15 choosing among themselves. And of course, in order to prohibit the situation that the court has gone through in the recent past, so that the Chief Justice really is a leader, and therefore also to maintain the independence of the Supreme Court. Because you see, the Chief Justice is different from any Associate Justice. The Chief Justice is primus inter pares. Can you outline for us very briefly how you would go about proposing the resolution of this petition if you were member in charge, and what your resolution would look like?
Regarding the prospect of ventilating a Rule 65 petition, Your Honor, in the sense that there is this intention to stave off the process through the JBC, I am inclined to disallow the Rule 65 petition on the idea, Your Honor, that the JBC is also independent within the sphere of the...
You're familiar with the case of Jardeleza versus JBC,
Yes, Your Honor.
where the court granted prohibition?
Yes, Your Honor.
You're familiar with the case of Aguinaldo versus JBC,
Yes, Your
where
Honor.
the court granted prohibition?
Yes, Your Honor.
These are precedents, correct?
Ye-
So are
But-
you now telling the Judicial and Bar Council that you are a justice that would go against the narrative of canon?
Regarding the case of Justice Jardeleza, I think the issue there was the aspect of denial of...
Regardless of the merits of the case, prohibition was ruled as a proper remedy. Would you recall who the ponensya was?
I think Justice...
He is an
Perhaps.
erudite
Justice
justice.
Carpio, I think, if I'm not mistaken. Justice...
-1 ka kagad. But in any case, so you've answered my question regarding your propensity regarding doctrine. Now, on the merits of the provision, how would you go about interpreting this provision? You see, the petitioner says, first and foremost, you do not only read the text of the Constitution, you read it in the context of how the Constitution is. And there is such a thing as independence of the judiciary. Therefore, there has to be a way of interpreting the Constitution such as to grant it more independence, while at the same time balancing it off against checks and balance. All the members of the Supreme Court, all the members of the Supreme Court are appointed by the President. But the Chief Justice should be selected by the members of the Supreme Court in order that there is true leadership in terms of the court. Would you agree with that argument?
I would tend to agree, Your Honor, but I would now seek the... I would like to look at it on a different level this time. And I would perhaps utilize Section 1 of Rule 65 regarding the possible...
No, but to be a justice of the Supreme Court, and I think my former colleagues will bear me out, you cannot just be procedural. Once you've hurdled the procedural argument, then you have to actually deal with the substantive aspect. And to be frank with you, I think this is something that must be overcome by those that have had a career as a judge. Because, of course, the emphasis in the lower courts are usually procedural. But in the Supreme Court, you will have to grapple with the substantive issue by its horns. The same way that, let us say, the eminent Justice Tiham grappled with the issue of not only quo warranto as a procedure, but the text of the Constitution in relation to the qualifications of a Chief Justice. Although I dissented in that case, it was a pleasure to dissent to such a finely written piece of work. So you will have to grapple with the substantive issue. Can you demonstrate to the court your philosophy of constitutional interpretation by walking us through how you would arrive at a solution to that issue.
Oh, I understand the JBC is equally independent, but when the Supreme Court speaks, the Supreme Court is interpreting actually.
Now put yourself in the position of an associate justice.
The
case was raffled to you. And of course, because a case is raffled to you, you carry the weight of the world. Because you will initially propose a solution, and because you are met with 14 other, let us say, stubborn minds, then you would have to attempt to find a consensus among all the strongest minds sitting in the Supreme Court. Of course, they can articulate their position quite vividly and quite persuasively, and that is the challenge for every junior member, would be to try to articulate his position. So now, maybe in just 2 minutes, can you walk us through how your solution will be?
My possible solution there, Your Honor, is to consider the supremacy of.
And by the way, sometimes you only have really 3 to 5 minutes in the court and bank to state your position after having circulated your ponencia. And of course, the other justices will patiently wait, but because you're the ponente, after you've spoken, one by one, they will deconstruct your arguments. So you will have to do it in 2 minutes. By the way, is this the job that you really want?
I guess so, Your
Yes,
Honor.
okay. Can you walk us through? Just 2 minutes.
Regarding this prospect, I would say, and I would assert the supremacy of the Constitution in the sense that the Supreme Court, when it pronounces its verdict, is towards the supremacy of the Constitution rather than the autonomy of the JBC.
I'm sorry, Justice, I don't get it. Supremacy of the Constitution
When the Supreme Court
includes
speaks,
the power of the Judicial and Bar Council to have its own discretion as to who to interview and how to vote. Supremacy of the Constitution includes Section 4, Paragraph 1 in relation to Section 9. We're talking about 2 constitutional provisions. One, the power of the JBC. There is precisely a conflict. And when you say supremacy of the Constitution, in this case, doesn't really make any sense, Justice.
the interpretation of the Supreme Court, whenever it speaks before it, through this petition for prohibition.
Yes, I want you to speak for the court now as a ponente.
I would entertain this time the petition for prohibition.
Okay. I think we've had our feel of the of how you would approach a problem. Justice De Los Santos, what is
afternoon,
meant
Honor.
by SOGI? SOGI. Because you did
Soji, yes, Your Honor.
say you did
Yes, I
enter
think the
into
meaning
that
is.
question.
Yes, Your Honor.
I'm sorry. You did enter into that question when you were asked by Judge De Monteverde. So I would presume that you actually know a terminology which you use.
I think Soji means sexual orientation. I memorized the meaning of that, Your Honor. It's a gender, identity,
Justice De Los Santos,
expression.
the public requires of the members of the Supreme Court to be responsible about the premises of their argument.
Yes,
And
Your Honor.
often, of course, many of us would say in open deliberation that I'm sorry, I am not familiar with that term. Let me do some research on it before I state my position.
Yes,
So
Your Honor.
would you
Actu-
rather say that you are not familiar
I am
with
familiar.
SOGI?
I am familiar with that, Your Honor. I have even read
Sexual
the
orientation, gender
Yeah,
identity, and gender
expression,
expression.
Your Honor. Yes,
Okay.
I have even read the bill, the bill, Your Honor.
In fact, it is not SOGI, but SOGI SC.
SOGIE.
SC, correct?
Yes, yes, Your Honor.
And SC refers to sexual characteristics, correct?
Yes, Your
Again, Justice De Los Santos, a very important responsibility of any associate justice of the Supreme Court, in my mind, including myself, is to admit that one is not knowledgeable about a label or a topic for which a lot of lives matter. And there is no shame in saying, I'm sorry, I do not
Yes,
know
Your
it for
Honor.
now, and let me just read up on it so
Yeah.
that I can participate more intelligently.
I'm sorry, Your Honor, but
Are you familiar with SOGI?
I have read the law, Your Honor, copy of the law.
No, not the law. Are you familiar with the lives of people dependent on the term SOGI?
I can say that I'm familiar with to
Are
a certain
you a
extent, Your Honor.
transsexual?
I'm not, Your
Are
Honor.
you transgender?
No, Your Honor.
So are you familiar? I'm
From
sorry,
what,
Justice.
when you
but
say familiarity, Your Honor, I think I base it from my
I am
observation.
cis. I am CIS. That means I'm heteronormative, heterosexual. But I did some work even before I wrote the case of falsis, which is now 109 pages. I just signed the Gilbert.
Yes, Your Honor.
In order to understand this issue, and I am pleasantly surprised that I knew very little before I actually wrote and before we actually deliberated on it. I think Justice Noeltiam was also in the bench when we had the oral arguments. Okay. In any case, you did mention that there is no case at all where a transgender has been bullied in a male CR.
I would say, Your Honor, that there have been no reports. I didn't say that there
Are
is
you
no case.
ready to make decisions that have nationwide import on your belief?
I have to admit, Your Honor, that I don't have the statistics because what I was trying to
But
emphasize,
what
Your
I'm
Honor,
saying is that when you make a factual premise, wouldn't it be careless to actually say that you are certain that nobody has been bullied? Because there have been many, and they have testified both in Congress and in many lower courts. And I can cite to you journal articles,
to
including one which I wrote, which I cited in a concurring opinion in the case of Drilon versus Garcia. It is an academic journal refereed that there has been bullying that happened inside male CRs to other males. And therefore, the proposition that sexual characteristic alone is what should distinguish is quite a dangerous one.
That's why, Your Honor, I said that I am in favor of this SUGI bill. We have to recognize the rights. We have to give them protection.
You missed my point entirely,
Yes.
Justice.
Uh,
What
okay.
I'm saying is, would you admit that sometimes we have factual premises in our standpoints that we need to step back a little, be more open-minded, because some of our factual premises might be wrong.
I agree with Your Honor. When I said those statements, Your Honor, I'm sorry, I just based it from my
Would you
experience.
agree with me that part of the qualification of an Associate Justice of the Supreme Court is his ability to be a bit humble enough to be able to check his own premises?
Yes, I agree, Your Honor.
Yes.
Humility is always
In my 7 years in the Supreme Court, many of my more senior colleagues have checked me once in a while, and I have stepped back and studied more carefully on matters which I did not know anything about when I started.
Yes,
Yes, and in any case, just sharing with you some of my experience. In Section 1, Article 3 of the Constitution, can you recite this provision?
I cannot memorize the provisions of the Constitution, Your Honor.
Article 3, Section 1.
I can understand the provisions of the Constitution, but I cannot memorize all these provisions,
No
Your
person
Honor.
shall be deprived of life, liberty, or property.
without due process clause.
The next clause.
No person shall be deprived of life, liberty, or property without due process clause, and
Nor shall any
no children
person
be denied equal protection I think equal protection of the law.
of the laws.
Yes.
Nor shall any person,
Person be
correct?
denied, yes.
Is there a qualification on person?
No, of course, Your Honor, no
There is
qualification,
none.
yes.
So it does not mean a white person or a black person.
It's not, Your Honor.
Doesn't mean a bald person or
It's
one
not,
with
Your Honor.
long
It's a
hair,
generic,
correct? Yes. As a matter of fact, there is Article 2, Section 14, which states, the state shall ensure the fundamental equality before the law of women and men. There is a difference between Section 14 and Section 1. Would you be able to spot the difference? Section 14 again says, shall ensure, the state shall ensure the fundamental equality before the law of women and men. Whereas Section 1, the original, only states, nor shall any person be denied equal protection of the law.
Well, I would even say that if there is a collision, Section 1 should be preferred, should prevail, because it refers to person. There is no distinction between men and women. So if there is a need to interpret the law, that Section 1 should prevail.
Yes.
because it is more human interpretation.
Yes.
There is no discrimination as it sounds.
Yes. And, Justice De Los Santos, would you agree with me that the life of an associate justice, because he or she puts his or her thoughts in writing, and it becomes jurisprudence,
I agree, Your Honor.
is more difficult than a Court of Appeals justice?
Yes, yes, Your Honor.
Because for forever, throughout history, when you make the wrong decision or write the wrong phrase, such as Oliver Wendell Holmes in the case of Buckley versus Ohio when he agreed with euthanasia or eugenics, okay? Now we'll have to live that down. So therefore, it is difficult in the court because it is not only quantity, but likewise the quality of your work.
Yes, I agree, Your
Yes.
Honor.
Are you willing to have that kind of life?
Yes, Your Honor. All my life, been in the judiciary writing decisions, Your Honor.
Yes, and as my colleagues have told me as I started my few months in the court, be careful what you really wish for in any case. So
Thank you, Your Honor.
may
for
I
that.
now refer to Judge Badeles. Justice Badeles, I'm sorry.
Your Honor.
I'm sorry. In Re Tony Valenciano, the complaint of Tony Valenciano was that there were Catholic masses that was conducted every lunchtime in the Regional Trial Court Hall of Justice in Quezon City. Would you vote for the majority there or join the dissent?
To be honest, Your Honor, I have not read the case, Your Honor.
Oh, you have not read that case?
Yes,
Where
Your Honor.
this is the seminal case regarding masses in halls of justice.
Yes.
It is a landmark case, written again by a very eminent jurist. Would you know who? Huhula ka na lang sa aming tatlo dito.
At any rate, Your Honor, I believe the holding of masses could be justified, Your Honor.
Yes, who was the ponente?
I have no idea, Your Honor, because I have
No
not
idea.
read.
Pogi. Very handsome justice.
I don't know.
And, except
Yeah,
me. Yes, Justice Bambit wrote the main opinion. Would you know the voting in that case?
As I said, Your Honor, I have not read the decision.
Would you agree with me that part of the role of an associate justice is to do the extra reading with respect to these cases?
Yes, Your Honor.
Yes. It was 14-1, correct? It was 14-1. Would you know who the dissenting opinion was?
The case
It is
of-
easy. He is always in the dissenting position. Yes. So would you vote for the majority or the minority?
I would guess that the majority voted to
Siyempre,
to
because
uphold,
iniisip
uphold
mo,
the holding of the masses,
One
Your
will
Honor.
vote, the other will not vote
Yes.
in the JBC. So you will go for the vote. No, I'm just kidding.
In my opinion, Your Honor, the holding of masses is not is valid, Your Honor, and justified considering that it is part of our socio-religious
Oh, my God.
practice, Your Honor.
In other words, you are for the injection of religion into the secular world. There is Section 6 of Article 3 of the Constitution. Would you be able to recite the contents of Section 6?
I think it's
Section 6, Article 2 is already the separation of church and state shall be
I think
inviolable.
it's about the funds. No funds should be.
Article 3, Section 6. Article 3 is Bill of Rights.
Yes
You
or
are-
no?
Maybe you're
not-
referring to Article 6, which is the legislature. But Article 3, Section 6 is, no law shall be passed,
no law shall be passed for the
made
establishment.
respecting the establishment of a religion
Yes, Your Honor.
and the free exercise of one's religion, correct?
That is correct,
Okay.
Your Honor.
Isn't this a violation?
No, Your Honor, because as a matter of tradition in our country, Your Honor.
Precisely, that's why there was this provision, in order that the dominant religion will not subsume those who are atheist, agnostic, etc.
Because it has a laudable effect on the part of the people, Your Honor. That's why you will allow this.
A petition for mandamus is filed against a justice of the Court of Appeals who refuses to recite the ecumenical prayer. Would you grant or deny that petition?
What
A
would be the-
petition for mandamus is filed to compel a justice of the Court of Appeals
I assume that
to recite
he
the-
is invoking his right, freedom of religion, Your Honor.
regardless. He refuses to recite the ecumenical prayer. Does he have to he or she have to justify why he will not recite the ecumenical prayer? Does he or she have to reveal that he or she is agnostic, Buddhist, Taoist, Satanist, or atheist? There are 7 types of atheists, by the way. Will you require the justice to recite it? How would you go about interpreting that provision that we mentioned? First of all, will you grant mandamus?
Against the justice who
litigant
refuses.
in the Court of Appeals attended a hearing on preliminary, gawin natin exciting, writ of amparo. The justice refused to pray, refused to recite. He stands up and is silent while the ecumenical prayer is pronounced. Would you grant mandamus?
No, Your Honor. Because that is his personal, I cannot compel him, that justice, to do what is against his personal belief.
Yes. Would you know of any justice of the Supreme Court that does not recite the court's prayer?
I do not know, Your Honor.
Really? Again, choose among the non-handsome.
I don't know, Your Honor.
So, because you did mention about religion a while ago, Justice Bruselas, just a few questions, please.
Yes, Your Honor.
Section 19, paragraph 1, neither shall the death penalty be imposed unless for compelling reasons. You remember this
Yes.
provision?
Yes, Your
Unless
Honor.
for compelling reasons involving heinous crimes, the Congress hereafter provides for it. Okay. You did mention a Supreme Court case which interpreted the concept of heinous crimes. In the light of 7659, which
crimes,
also has a congressional interpretation of heinous crimes. Correct?
Yes, Your Honor.
Yes. Is the Supreme Court entitled, as the interpreter of the Constitution, to read heinous crimes other than how Congress has read it?
If it is a question of interpretation, Your Honor, the Supreme Court can do that. But if it's not a question of interpretation,
Here in the provision, it says, constitutional provision, for compelling reasons involving heinous crimes. It did not say as defined by law. It did say involving heinous crimes, the Congress hereafter provides for it. So, would you not say that Section 19, subparagraph 1, allows the court to interpret the constitutional phrase, heinous crime?
in the first place, Your Honor, the matter of legislation, it will be the first attack of the Congress to say what exactly they mean by heinous crime. And then when it's brought as an issue before the Supreme Court, then that provision of the Constitution which says for compelling reasons.
Yes,
may
of
be
course, that's the
inquired
doctrine
into.
of legislative primacy. But after legislative primacy comes the Constitution.
Yes, Your Honor.
Yes, and would you say that the court has the power to interpret heinous crime?
If
And tell the Congress that that is not the proper interpretation of heinous crime?
it will have to go back to what is the compelling reason.
Well,
for
these are
compelling reasons, because that will be the basis for Congress to
yeah,
enact
but
heinous
there are
crimes.
two things here. One is for compelling reasons
For compelling reasons.
involving heinous crimes. So there are two concepts here. There is the compelling reason and there is the heinous crime. So heinous crime, would you say that the Supreme Court should interpret heinous crimes by itself?
As I said earlier, Your Honor, if the law has already defined it, what heinous crime is, and under 7659 it says those punishable by perpetual death, then I don't think there is room for the Supreme Court
This
to
is a very dangerous doctrine
further.
that the Supreme Court will not interpret the Constitution if there is a law.
No, Your Honor, what I'm saying is if there is already a definition and
Yes.
it's not brought up as an issue, then the court,
No, it's an issue.
or if it's brought up as an issue,
Yes.
that's precisely why I
Yes,
say
that-
that.
that's
as
why
an
I'm
issue.
saying
Ah, yes, I'm
I
sorry.
want to see how you're going to interpret heinous crime.
If brought up as an issue,
Yes. What is your interpretative methodology for arriving at an interpretation of heinous crime?
well, first, Your Honor, we'll have, in my own case, I'll have to go back to what had been the experience of the court with respect to crimes. Then we extrapolate. What are these crimes that probably may fit into a definition of heinous crimes? What I'm saying is we cannot just imagine and conjure what heinous crime is without looking back into experience.
Would you go into philosophy
Well,
between what is a bad act and what is an evil act?
going into philosophy, Your Honor, actually, without our knowing it, when we discuss, when we argue, we are actually,
But that is what
resorting
the
to
Supreme
philosophy.
Court is for.
That's right, Your Honor.
Reason.
Without
Not
our
the
knowing,
majority, not the politically dominant,
that's correct, Your Honor.
not the voice of the crowd or a mob in a democracy, but reason, correct?
What is right may be one person as
Yes.
against a majority.
But
doesn't
heinous
make it
crimes,
right.
of course, can be collectively determined by a group of 15 intellectuals.
And in a democracy, Your Honor, the majority rules. They may not be correct, but in a democracy,
Yes,
the
but
majority rules.
that's good if you are running for congressman, but you are vying for associate justice of the Supreme Court. Are you saying that you are a conservative?
Philosophically, Your Honor, I'm in between, neither conservative nor liberal. I try to be.
I sense that you are more conservative because for heinous crimes, you would rather defer to Congress.
rather have the Congress first crack of what it is. And if it's brought up as an issue, then
And,
the court will come in.
Yes, and you
Well,
know
I'm
that,
saying that we should.
and you do know that, of course, we have a Bill of Rights, and usually in a majoritarian organ of government, in a political organ, the Bill of Rights is the first to go. Whereas in the Supreme Court or in any part of the judiciary, the Bill of Rights is respected. While people say that a person has already committed a heinous crime, made that judgment in media, and Congress does their own investigation in order to convince their political constituency, it's a court that says, wait a minute,
It is the function
let
of
us give it due process of law.
It is the
Let
function
us
of-
give it the presumption of innocence, correct?
It is the precise function of courts in a democracy.
Yes.
Precisely say that, Your Honor.
So what is in the...
If I may add, Your Honor, there is
Yes.
also a theory. You mentioned about majoritarian system. There's also a theory about counter-majoritarianism, where there is a developing theory that the Supreme Court, being an elective group, cannot overwhelm in a democracy, Congress. That's just a theory, you know? That's what I'm saying, Your Honor. But
That
when you
is-
come to what is right,
The word
majority doesn't mean-
counter-majoritarian ethic of the Supreme Court was introduced by John L. And Bruce Ackerman, among the other more contemporary writers, would say that the counter-majoritarian ethic of the court is there in order to correct a democratic deficit, which means to say that in certain instances, well, like for example, declaration of martial law, when people think that it is very needed, it is a court of law that steps back and looks at what are the constitutional requirements, what are the reasonable requirements. And when everybody wants to kill just because there are heinous crimes, when everybody wants death penalty, when there is a heinous crime, the court will say, wait a minute, there are several philosophies of punishment, namely retribution, restorative justice, preventive, and deterrence. And more often than not, we forget also the imperfections of our judicial system. And therefore, there has to be a strong body that weighs against the hue and cry of the crowd. Yes, okay. Now, I have a final question to all of you. 3 months after I was appointed as Associate Justice, 3 months after, I was asked to vote in a case entitled Gonzalez versus Executive Secretary. My colleagues know that the vote then, before I entered, was 7-7. And I cast a vote against the appointing authority, my appointing authority, which is why there is now a doctrine that the President cannot remove a deputy ombudsman. That was my vote. Okay, 3 months after I was appointed. Now, just a brief question to all of you. Are you ready to vote against President Duterte when you think that the doctrine that they follow is wrong? Justice.
If ever, Your Honor, I be elevated to the Supreme Court, what should prevail is that justice should be served. So it's not whether or not it is the opinion or the decision of the President.
So what's your brief answer? Yes or no?
Yes, I can go against his decision, Your Honor, if it contravenes what I feel is just and right on that issue, Your Honor.
Oh, are you here to do what you feel is just,
Yeah,
or are you
what I
here
mean
to
is-
do the law?
Do the law, Your
Yes,
Honor.
okay.
When I find that it is against the law, then it should be struck down, Your Honor.
Yes. You remember Learned Hand shouted to Justice Oliver Wendell Holmes, "Do justice, justice." And Oliver Wendell Holmes shot back and said, "That's not what I do. What I do is I do law, not do justice." You, of course, know the difference. Yes, in any case, Justice Bruselas, same question. Yes or no?
Yes, Your Honor, because if it's a matter of the Constitution and the law, then we uphold Constitution and the law, Your Honor.
Yes. Justice De Los Santos.
Yes, Your Honor.
Yes.
Even it will be against the wishes of any leader, I would perform my job as a magistrate of the law by rendering justice as what the maxim says, heavens may fall as long as we have to render justice.
Fiat justitia ruat caelum. Yes.
I would vote in favor of the supremacy of the jurisprudence.
Thank you, Your Honors. I am sure that this will be sent to the appointing power. Just
Thank you
kidding.
so much.
Are there any to the other members if there are questions?
Can I yield it to Justice Tihamni because I have to be excused for a while ago.
Thank you, Judge Zilo. Thank you, Chief. So as a follow-up to what Justice Leonen has inquired into, if you join the court, will you be hesitant to revisit doctrines, hesitant to revisit decisions of the court only for purposes of judicial stability? Justice Badelleles.
I believe, Your Honor, it depends on the circumstances of the case, Your Honor. There may be instances when one has
Because
to be...
the mindset of a justice of the Court of Appeals is that when you decide a case, you decide it in accordance with a decision of the Supreme Court. But now you are in the Supreme Court. Are you bound by jurisprudence enunciated by the Supreme Court? Or can you rethink or revisit the rulings of the court just so there is judicial stability?
Well, following the doctrine of judicial stability, Your Honor, as a justice, assuming I'm already there, member of the court, my first instinct would be to follow the doctrines already established by the court. However, as I said, depends on the circumstances. If it appears that this will lead to injustice, Your Honor, I will not hesitate in
But what
reversing
would be
or
your
amending.
standard? What would be your standard to say that it will lead to an injustice? What would be your standard? Will it be your moral convictions, your moral judgment that will affect your decision on the case?
No, Your Honor. It depends, as I said, on the circumstance of the case, Your Honor. Because
How do you gauge yourself as a jurist? Are you a wavering jurist? Can you easily change your mind one way or the other?
if the argument is valid, Your Honor, yes, I can be persuaded, Your Honor. But as a rule, as I said, I am more of a conservative in the sense that I would stick to precedents, no? Unless it can be shown that these precedents no longer serve the purpose of justice. It's against public interest, for instance, Your Honor.
Justice Peralta, I have known you for many years. Are you that kind of a jurist who would stick to judicial stability, to existing jurisprudence? You don't want to rock the boat. You will not have an open mind about a particular issue presented before the court.
Regarding the prospect of deviating from established jurisprudence, I would like to think, Your Honor, that ordinarily we should stick with jurisprudence. But if the issue now presented before the Supreme Court is quite novel, I understand there is a pending petition with the Supreme Court on the question of Article 992, the new Civil Code, and the prospect of abandoning it altogether, then perhaps we should really re-examine jurisprudence.
Justice Bruselas,
Yes, Your Honor, please.
we have been together since RTC Quezon City.
Yes, Your Honor.
Do you think it is appropriate for the court to revisit or reverse decisions of the court once the ponente and the majority who concurred with the decision have already retired?
If the issue is brought up in such a way that there will be a need to revisit or re-examine a previously settled doctrine, then by all means, I will be open to that. But the issue must be phrased in such a way that there is a need to re-examine it. There are lawyers who are very, very good and are able to present something to the court and inveigle the court to revisit something when in fact there is no need to revisit something.
You are an associate justice of the court. The senior members of the court are still in the court. They were responsible for creating that jurisprudence. They concurred with that jurisprudence. But you have some doubts about the propriety, the validity of that jurisprudence. Will you defer to your seniors by just maintaining the status quo?
As I said,
not be proactive about it and think deeply about revisiting it or revising it?
it's not a matter of deferring to the seniors in the court because, as I understand it, all the members of the court are equally competent. It's a matter, Your Honor, of whether or not there is a need to revisit it, and that will not be based on how I view it, how I see it personally, but how it is brought up by a pleader. The pleader will have to convince me that I have to revisit. So, with respect to the question of whether or not am I averse to re-examining previously settled doctrines, no, I'm not averse to it. What I'm only saying is that as a matter of rule, the court should, as much as possible, refrain from revisiting where there is no need to revisit, especially when the re-examination is only based on a member's perception of what he thinks is correct. It must be based on an argument raised by a party.
Justice de los Santos.
Same question, Your Honor.
Yes, same question.
Generally, I am for judicial stability, but I will not hesitate to revisit doctrines or decisions, whether or not decided by retired justices or incumbent justices, if I believe that the issues are novel or of transcendental importance or national importance. I will not hesitate, Your Honor.
Did you say transgender importance?
No, transcendental. We have already moved on after that issue, Your Honor. And if it is of national importance, rather transcendental importance, I will not hesitate to revisit the doctrine or the decisions penned by a retired justice or even an incumbent justice. It's not for lack of respect or not referring to seniority, because law is dynamic too. So if I have to decide a case, I have to temporarily forget that the ponente is more senior than me. It will take a backseat.
As a new member of the court, what will be your attitude? Will you be an observer? Will you be a fence sitter? And you will just try to look at both sides, and then whichever the wind blows, you'll go that way or this way? Or would you aspire to be a maverick justice like Justice Leon?
Your Honor, God willing, I'll be appointed, I won't be what you mentioned a while ago. Perhaps I am more inclined also to be like Justice Leonen, but not 100%. I have to weigh things. I don't have to be affected by the fact that I am a newcomer. I respect the decisions of my seniors, but I have to have my own frame of mind. I have to decide the case according to how I look at it, not because I have to be prevented from deciding because I have to respect my more senior members, or just to go where the wind blows. I have to be independent, and if there's a need to become a maverick, I would not hesitate to be one, Your Honor.
Among the four of you, which one of you is in favor of reviving the death penalty? Can you raise your hands? Death penalty, reviving.
Yes, for compelling reasons, Your Honor.
And those against reviving the death penalty? So, Justice Bruselas. So my question is, can you think of any legal impediment that will pose as an obstacle to the revival or the reimposition of the death penalty? Can I start with Justice Peralta? Is there any legal impediment you can think of?
Regarding the legal impediment, Your Honor, I'm not aware of any legal constraint, provided it is in keeping with the wording of the Constitution. I think it's in Section 21, Article 3 of the 1987 Constitution. But by way of enlightenment of the good Justice Leonen, if I may just follow up, perhaps there would be a constitutional issue if there is a question of whether a crime is in fact heinous or not. So I think that would perhaps present a very interesting field.
Justice Badelius, can you think of any legal impediment that will be an obstacle to the reimposition of the death penalty? Is there a legal impediment?
I agree with Justice Peralta, Your Honor, that it appears that there is none, except perhaps as to the definition of what is heinous. If, for instance, Congress would include crimes or offenses that are not as grievous or as onerous as malevolent, Your Honor, then there might be a question, Your Honor.
Justice Bruselas,
Can
you think of any
yes,
impediment?
I am not very, I'm trying to recollect, Your Honor, but I seem to have read a sort of a convention, an agreement, where the Philippines is a signatory of, Your Honor, and that appears to be the matter of prohibiting unusual and cruel punishments. I just do not know
what is the second protocol of the
Yes.
International Covenant on Civil and Political Rights?
I think precisely, well, I will be very frank, Your Honor, I have not gone over that particular second protocol on civil and political rights. But as I said, my recollection is that the Philippines appears to have signed a convention, and maybe a protocol, that prohibits cruel and unusual punishments and includes the death penalty. Although if Congress were to pass death penalty and there is a conflict between the domestic law and international law, I think we follow U.S. jurisprudence where domestic law prevails.
Justice Edsa, what is the ICCPR? What is that? Have you heard about it?
Am I correct, Your Honor, that it refers to their National Criminal Court, Your Honor? ICC?
ICCPR. What is it? Have you heard about it?
I'm sorry, Your Honor, I have not heard
It's
of
the
it.
International Covenant on Civil and Political Rights.
I have not read that, Your Honor.
In June 2006, President Gloria Macapagal Arroyo signed Republic Act 9046 abolishing the death penalty. And on that same year, the Philippines signed and in 2007 ratified the second protocol of the International Covenant on Civil and Political Rights, irrevocably abolishing the death penalty. It is the second protocol. Would you know the difference between the first protocol and the second protocol?
Come again, Your Honor. What's the first protocol?
What's the difference? The country signed a second protocol.
The second protocol refers
So
to...
presupposing that there was a first protocol that was signed by the Philippines as well, what is the difference between the first protocol signed by the Philippines and the second protocol that was signed by the Philippines in 2007?
The second
Can you venture a guess?
Can you second? I presume that there was no such abolition in that first protocol, because the second protocol mentions that the Philippines signs the second protocol abolishing the death penalty.
Both the first and the second protocol relates to the abolition of the death penalty. Now, the difference is that in the first protocol, there was a withdrawal clause, whereas in the second protocol, there is no withdrawal clause. In other words, the Philippines is committed to that international convention, to the abolition of the death penalty. So why is it an impediment?
Perhaps, Your Honor, because international laws or treatises entered into by our country.
What will happen if we renege on that
aside from
second protocol and reimpose the death penalty? What will happen to us?
aside from adverse world public opinion, we'll lose our face before the eyes of the international community. Because
Is our face important
because,
in the international community?
But I mentioned that, Your Honor, but above all, what is important is our domestic laws, our constitution. It should prevail over and above whatever international agreements we have entered into. Like, for instance, in the constitution, regarding the provision about death penalty, which is not per se prohibited as long as Congress will enact a law, and it pertains to heinous crimes, and there are some compelling reasons.
Let's talk about the good conduct time allowance. Justice Badelles,
Yes, Your Honor.
have you read the law?
Yes, I scanned that law, Your Honor.
You
Yes,
scanned through it.
Just went
How
over
fast did you scan through it?
Just went over it, Your Honor. Just.
What is good conduct under the law?
I think it's equated to good behavior, Your Honor, during the time that the inmate
What is good behavior? Is it defined in the law?
Not really, Your Honor. I'm not sure, Your Honor, if there was.
So, can you venture a guess?
That he has not.
What is the meaning of good conduct or good behavior that will entitle a convicted felon or a convicted PDL from, what is a PDL, by the way?
Person deprived of liberty.
That will benefit a convicted PDL of the good conduct time allowance. So what is he supposed to do to benefit from it?
I recall, Your Honor, that among others, he can be credited good conduct if he, for instance, participated in mentorship
That's
program.
the right question to the wrong, that's the right answer to the wrong question. The question is, what is good conduct? Is it something positive or something passive?
It's more passive, Your Honor, that he has been complying or obedient to the
So if
rules.
If a prisoner is just loitering around for years, that is good conduct.
Yes, he has not been involved in any.
That is good conduct.
Fights
Because the law does
or-
not define what is good conduct.
Yes, Your Honor.
It does not mean something positive, to do something good, but rather not to do something bad. That is good conduct.
That I suppose, Your Honor, because he has followed the rules and obeyed all the orders of the custodians, Your Honor. Then he is considered as a PDL with good conduct, Your Honor.
Is that law constitutional in your mind?
Yes, Your Honor.
Why? is it constitutional?
Oh, there is a this is in consonance, Your Honor, with one of the theories of
Are all
penology,
laws-
Your Honor, that
Are all laws passed by Congress constitutional?
we just we say, Your Honor, that the rule on the laws of Congress are constitutional, Your Honor.
So all of them are
Yes, Your
constitutional?
Honor.
So there is nothing, nothing else for the Supreme Court to do since all laws passed by Congress are constitutional?
Unless it is expressly directly challenged, Your Honor, that's the only time. But then the presumption is always that the laws are
You're
valid
saying
and constitutional.
presumption of constitutionality.
Yes.
But you cannot make a categorical statement that all laws passed by Congress are constitutional. As
Only
in
a
fact,
presumption, Your
some
Honor.
laws have been declared
Yes, Your Honor.
unconstitutional. Justice De Los Santos,
Yes, Your Honor.
is the good conduct time allowance law, in your mind, constitutional?
I would venture to say, Your Honor, that that provision is not constitutional.
Why?
Like
You
for,
want to disagree with the previous
Yeah,
justice?
with due respect to my
Why
colleague.
is it not constitutional?
Because there is that provision about the granting of good conduct time allowance, and it provided that it is not, it is irrevocable, something like irrevocable. Once granted, it cannot be revoked. Now, that portion is beyond that portion is contrary to the provisions of the Civil Code. It's even prohibitory, something prohibitory. It runs counter to the provision of the Civil Code. And by saying that it's irrevocable, it would seem that it's beyond the ambit of review from our courts. So it is similar to an irreparable law. The Congress, even despite its vast powers, cannot promulgate or enact laws that cannot be reviewed by the courts of justice. So for me, that is unconstitutional, Your Honor, to respect.
Justice Bruselas, is it within the reduction of sentences, reducing the period of detention, reducing the punishment for convicted felons, is it within the realm of the executive or within the realm of the judiciary?
Is essentially, Your Honor, a power of commutation to reduce sentences. So that is within the domain of the executive. So that's
Who
what
in particular in the executive exercises
it's
that
the
authority?
it's the chief executive, the president, Your Honor, under the Constitution.
So the president, upon recommendation of the Board of Pardons, can pardon?
Well, the president, upon recommendation of the appropriate agency, it may be the BPP, and it can commute, grant pardons and reprieves,
Yes.
grant amnesty. Upon
Now, the
recommendation of
provision,
appropriate...
the provision of the good conduct time allowance reposes not to the president, but to the
Bureau of Prisons and
Bureau
other,
of Prisons,
and other direct...
the
yes.
authority to make the computation. Are they also authorized to release based on the computations they made?
The good conduct time allowance, 10592, Your Honor. Let's try to understand this, contrary to the view of my colleague. The matter of granting good conduct and then a provision that says once granted, if it may not be revoked, is not new. That is in the revised penal code. That's in Articles 29, 94, 97, 99. So what we know as the good conduct law is not really a new law. It simply increased the time allowances granted under the revised penal code. So the question is, may the release be effected without the president's approval? If it's a matter of complying with these provisions and once computed, the prisoner is deemed to have served his time, then release should follow as a matter of course. It is not a matter of reprieve or amnesty that should be brought to the President. I think it's too small a matter to be brought to the President. The other new one, Your Honor, is under the revised penal code, it's only the Director of Prisons who can grant time allowances for good conduct. The new law expands this and grants the Director of the Bureau of Jail Management and Penology, the city jail warden, the provincial jail warden, and other district jail wardens. This is a new provision which has not been granted before under the old revised penal code.
Are both laws constitutional, the revised penal code and the good conduct time allowance law, considering that when a person is prosecuted, charged in court, convicted, and sentenced by the court in pursuant to the penalty provided under the law, the good conduct time allowance in effect modifies the full service of the sentence imposed by the court. Is that not an undue infringement on the power of the courts?
I respectfully do not agree with that conclusion, Your Honor. That provision on the good conduct time allowance is pursuant to the positivist theory of our revised penal code. We have the classical theory, which is retributive, and the positivist or reformative, which looks at the offender as a person who can be reformed. So when you grant this grant of good conduct time allowance is in pursuance of that theory.
So there's nothing intrinsically wrong for the executive department to abbreviate, to shorten the sentence imposed by the court in accordance with the law.
In the end, a person who may have felt aggrieved by that can go to court. There is always a remedy. But what I'm saying is, under the state of the law that is in place, it is not unconstitutional. Because so long as you carry out the matter of compute, the whole issue about this releases is that there is no standard of computation. It is left to the computation of the Director of Prisons. And under the new law, the BJMP Director, the city jail wardens, the good conduct time allowance, as inquired into by the Honorable Justice, is it a matter of doing something good or simply not participating in any riots? We are not clear about that. But as I understand it, per their internal rules and regulations, good conduct is viewed not so much as doing good behavior, but refraining from doing something bad. That's why they have a list of violations. The new one also is the time allowance for study, teaching, and mentoring. That's something new. And the other one is time allowance for loyalty. That they increased that from 1/5 to 2/5. That's also in the old law already, where an escapee returns to prison after a disaster or calamity on his own, voluntarily.
Prisons are called correctional facilities. They're supposed to correct. So when somebody is put in jail, detained, he keeps quiet, he does not do anything. Has he underwent correction and rehabilitation?
That's the novel, precisely the change in the name, Bureau of Corrections, is precisely to infuse, to convey the message that the prisons should not be viewed as, you're confined there, you die there and lie there. It's supposed to be a facility where human material may still be rehabilitated. That's why it's a Bureau of Corrections, Your Honor.
What about the President announced that he personally ordered the transfer of some high-profile convicts from Muntinlupa to another detention facilities because these were people who testified against detained former Senator Laila de Lima, and for security reasons, the President ordered their transfer of detention. Was this a valid act? Does it not require permission from the court? Justice Peralta.
Based on my reading of the situation as presented by Good Justice Tiam, I'd like to believe that there was a memorandum of agreement which served as the basis for the justification of presidential prerogative. Because apparently, the memorandum of agreement between the Director of Prisons, if my memory serves me right, as well as the BJMP and the AFP, virtually permitted the prospect of moving these prisoners
But do
elsewhere.
you have to notify transfer of detainees, of detention prisoners require notice to the courts, correct?
Perhaps,
You cannot just transfer from one place to another place without informing the court about it.
Perhaps that would be the prudent course to follow. But perhaps I can also surmise, and this is just speculation, perhaps the President was acting on the basis of intelligence reports as to the possible danger to the lives of these inmates, which warranted the immediate transfer, although I understand there was a MOA.
Justice Edsa,
Same question, Your Honor.
who can order the rearrest? Who can validly order the rearrest of detained prisoners who were released pursuant to the good conduct time allowance? Can the President order the arrest, or should it be the court who should order the rearrest?
If you allow me, Your Honor, to cite the case of People versus, I think, Fidel Tan. In that case, the court ordered the rearrest of the accused because there was a mistake in the computation of the jail warden. And according to the court, there is no double jeopardy, and in ordering the rearrest of the accused, the court is just simply directing the accused to fully serve his sentence.
That's
This case of,
the answer to my next
Yeah, yes.
question. So the question is, who is lawfully authorized to order the rearrest of these people? Should it be the President or should it be the court?
normally, I would say it should be the court because
And abnormally,
I'm not going to use that term, Your Honor, because with that good conduct time allowance law, it would seem that that law modified the decision in the case of People versus Tan.
how would you justify it? Since it was the executive who
the-
released them
The-
and they committed the mistake, it is also the executive who should rearrest them. Is that what you're saying?
The power of control belongs to the President. The President is the chief executor of our laws. And if there was a mistake, then the President, being the chief executor of our laws, has the power to order the rearrest of those complex
What
arrangements.
crimes were committed by these detainees who were released due to mistaken computation? What crimes did
I
they
think the rearrest, Your Honor, is not because of the commission of defense, but for purposes of recomputing
who committed the mistake?
the Bucor head, Your Honor, and the order of the President is primarily to double-check, make a recomputation, and for those who are really entitled to good conduct time allowance, they should be released. But the purpose here is that for those who were erroneously granted liberty because of the mistake committed by the Bucor officials, or for whatever reason, mistake or intentional, then they should be returned to jail for full service of the sentence. And that's within the power of the President, because I've said the power of control belongs to the President. And in fact, even if there are some powers that do not clearly belong to the Judiciary or to the Legislative, it should be interpreted as a power that belongs to the President.
Okay, one last question. Which quality do you have, obedience or independence?
I would rather
Justice
prefer
Badil-
independence.
Justice
Your-
Edsa.
Independence, Your Honor.
Independence. Justice Badelles? Justice
Independence.
Bruselas?
It's independence, Your Honor. It's one of the 6 canons of judicial conduct, Your Honor.
Justice Peralta?
Independence, Your Honor.
Are you willing to be independent of the Constitution or of the law?
Oh, is that question addressed to all of us, Your Honor? Yes, Your Honor.
All right, you should think independently.
Yes, Your Honor.
You obey the Constitution and the laws. That is what is needed in the Supreme Court.
Yes, Your Honor.
If you are a fence-sitter, you're just a mere observer. You're a mere joiner. The court does not need you there. All right, thank you, and good luck
Thank you to Your Honor.
everybody.
Thank you.
Thank you very much, Justice Tiam. Judge Ilaw.
Yes, thank you. Going back to the chair, Justice Mendoza. Yes, good afternoon, gentlemen. Are you already tired?
Good afternoon, Your Honor.
Good afternoon.
Tired na po ba kayo? So, Nerit, I'll just ask a few questions, considering that all of you are justices of the Court of Appeals, Tagala. And I really did not doubt of inviting Justice Leonen to be the presiding justice of the JBC. But it really have to be remembered that this is JBC, but not the Supreme Court. Yes, Justice Badiles, any substantial or notable changes in your last interview? You still sporting that whisker. You still
Well,
look good.
I might say, Your Honor,
like
that
Errol Flynn, Clark
since
Cable.
then, I'm now the chairman of the 23rd Division of the Court of Appeals in Cagayan de Oro, Your Honor.
Okay. Alright, Canon 1 of the new Code of Judicial Conduct states that judges, magistrates shall not only be free from inappropriate connections with and influenced by the executive and legislative branches of the government, but must also appear to be free therefrom to a reasonable observer. How would you ensure compliance with this requirement when the position calls for connections with officials of other branches of the government? You receive some endorsements coming from the city of Iligan
Yes, Your Honor.
and other private
I was endorsed
organizations.
by the Sangguniang Panglungsod, Your Honor. For that reason, I inhibited in cases involving them, Your Honor. That's in the list, among the list submitted to this court, to this body, Your Honor, to this council. Also, I was endorsed by my colleagues from the Court of Appeals, Your Honor.
And what if those endorsements would have a case before you if appointed as Supreme Court? How would you handle it without burning bridges or embarrassing those people whom might have helped you in attaining such a mandate of being the Associate Justice of the Supreme Court?
As I said, Your Honor, on grounds of delicadeza, Your Honor, I would have to inhibit because these are people who have helped me. For instance, assuming for the sake of argument that they helped me in getting appointed. Eventually, I have to inhibit myself in cases involving these people, Your Honor, because that would be inappropriate on my part. At any rate, I can always tell them, my usual response to these kinds of approach, Your Honor, is you get a good lawyer for that to help you in your case.
And we have received documents which we requested for the list of your cases wherein you inhibited for some reasons, overall of 91. So, being a member of many organizations as well in the judiciary with so many friends, do you think this is a curse or a blessing?
Well, it's neither, Your Honor. Having friends is good, Your Honor. But being influenced by them or to tilt the justice in their favor would not be appropriate, Your Honor. I would say that being involved in many organizations has expanded my view or my experiences, Your Honor. I have become a better person as a member, for instance, of the JC Senate. It has trained me to become what I am today. And I have learned a lot also as a member of the Freemasons, Your Honor. Rotary also, I was a member of Rotary. But since then, I have stopped being a member of Rotary because I thought it was too much of a burden already on my part, Your Honor. But on the whole, Your Honor, I see no negative effect on me on being a member of various organizations. In fact, it has helped me to be what I am today, Your Honor.
Justice De Los Santos. Canon 2 of the Code of Judicial Conduct states that a judge or magistrate should avoid impropriety and the appearance of impropriety in all activities, in and out.
Yes, Your Honor.
How have you embodied this requirement?
Your Honor, please, practically I don't have a nightlife. Aside from my work, my only passion is playing lawn tennis, Your Honor. If it's okay to mention this, I'm a member of the Worldwide Marriage Encounter. And aside from that, I've been active for about 15 years in the so-called Casa Cittadini, run by Ursuline Sisters of Sumasca, Italy. I am an active member. This helps the abandoned and neglected girls, Your Honor. I am more of a person who is from the office, and if I don't have much work to do, I go home and play with my grandchildren, Your Honor. These are my only activities, Your Honor. I don't drink, I don't smoke, Your Honor.
But you had previously that you indulge in the habal-habal. Is that not such appearance of impropriety, being a judge or a justice?
Your Honor, this habal-habal term was coined perhaps several years before I would say I was doing it. Actually, this is the meaning of habal-habal, Your Honor. Habal-habal is a habal driver is one who drives a motorcycle for a fee. And in Dumaguete, the roads are so small, and that's not only because the road are narrow, primarily because of financial situation. I could not afford to buy a four-wheel vehicle. The only thing that I could afford is to buy a motorcycle, and with all my children, my wife riding with me. And that term, habal-habal, in one of the articles written during the Father's Day, was just mentioned by the writer. He jestingly told me, so it would seem that you are the original habal-habal driver. And it's now famous. We have the so-called angkas. So I don't think if it's improper for me to be riding a motorcycle wearing barong with my wife and all my children, I could not help it, Your Honor. It's actually poverty, or it's beyond my means to buy a four-wheel vehicle, Your Honor.
All right, Justice Bruselas, have you penned a decision that was contrary to your personal moral belief?
No, Your Honor, not to my recollection. I have not encountered such a case where I penned a decision contrary to what the law says, and contrary to what the evidence says, and contrary to what my personal belief says.
All right, how many times have you been shortlisted? 9 times?
9 times, Your Honor. Thank you very much for the opportunity, Your Honor.
You're welcome always, but do you think that your promotion in the Supreme Court is not yours. For so many times you've been shortlisted, but yet you were not appointed.
It's correct, Your Honor. The appointment to the Supreme Court is not for us, for not an aspirant to really consider. One just has to prepare himself, and as they say, man proposes, God disposes.
What is your reputation in the office?
Unfortunately, Your Honor, it's one of being, the term is suplado.
Again.
The term is suplado, Your Honor, because I do not know why, because probably because they find it difficult for me to be talked to. But really, it doesn't really, to me, it's more of a shield, actually. But that's what I know, that my reputation is. It may not be accurate, but that is how I am told. Yeah.
How would your colleagues and subordinates describe you, both positive and negative?
Well, I do listen to feedback, Your Honor. I do not really concern myself with feedback about my personal behavior, so long as I do not oppress and harass or vex anybody. I am not a slave driver. To my recollection, no? My lawyers do not tell me that I am a slave driver, although I do am meticulous and I require a lot. So on an average measurement, Your Honor, I would say that I am the type that who is fair and reasonable, who exacts when something is to be exacted from, and who is also lenient and liberal when there is a need to be lenient and liberal.
Yes, Justice Peralta. Who do you look up to in the judiciary, more particularly in the Supreme Court, past and present?
It's a bit difficult because I know the almost all of the members of the Supreme Court are that erudite, and we can consider them as role models. So it would be really difficult to spell out who among them should be considered as more superior than the others.
And this a basic question trusted to all the members of the Court of Appeals. How come that decisions of the Court of Appeals do not get 100% affirmance from the Supreme Court? That's Justice Badilles. Is there something that meets the eye?
Sometimes, Your Honor, it's just the mere appreciation of the evidence, Your Honor. For instance, for us, we might rely on the fact that findings of the trial court are binding on us, but when it comes to the Supreme Court, they might have a different perspective, such that they might reverse the decision on ground of reasonable doubt. In other words, it's in the appreciation of the evidence, Your Honor. Like in one case, I recall Justice Lloren affirmed a decision of the trial court, but he was reversed because, according to the Supreme Court, a distance of 10 meters is not enough for the policeman to observe properly or to see properly the transaction subject of the buy bust. So it's matter of, to my mind, Your Honor, perspective, because in the Court of Appeal, sometimes we just rely on the findings of the trial court. That's it, Your Honor.
Yes, Justice Bruselas, that can you think of any innovation that there's no quarrel that draft decisions of the Court of Appeals in division are merely circularized? Unlike in the Supreme Court, draft decisions are being agenda or for deliberation.
I respectfully disagree with that comment, Your Honor. In my division, we set deliberations twice a month. The way we do it is first reports, draft reports, are circularized for the 3 members. Then they give in their comments, whether they have comment or not. If they don't have any comments, they just sign it. And then we agenda it, or those that have been circularized, for a deliberation on the, usually it's the 5th, middle of the month and end of the month. And we sit down, based on the agenda, what has been routed to them, and we have a second look, final look at this, our reports which we have previously agreed upon. So it's not correct, Your Honor, to say that reports, draft decisions of the Court of Appeals are simply circularized, at least not in my division. And this has been the practice that I have started since I became chairman of the Court of Appeals, Your Honor. I suppose this should also be done, or also being done by the other divisions. I'm not so sure, but I can very well be sure that in my division, that does not happen. And you can ask all the members of my division, Your Honor, past and present. Thank you very much.
Justice De Los Santos,
Yes, sir. Your Honor.
same question, please.
This is true, Your Honor, that we routed our drafts of the decisions, Your Honor. But we never hesitated to make some suggestions, or perhaps you call it reflections. If there are these such things as suggestions, reflections, or observations, being the chairman of the 18th Division of the Court of Appeals of Cebu, I call the 2 other members and for us to discuss these observations. And if we cannot agree, then we are free to make our dissenting opinion. In other words, we don't just blindly concur or fix our signatures. Or we make some observations, suggestions. For example, if we think that the penalty is wrong, we make some suggestions. If we think that if there are 3 charges, if we think that the accused should be convicted in the 3 crimes for which he was being charged, and there are only 2 convictions, we sit down with the other members of our division and discuss. So it's maybe it's not as often as what Justice Bruselas said, but we do perform our job. We examine, review the drafts of the decisions of the other justices, and we do not hesitate to make some suggestions. But if we cannot convince the ponente of our observations, then we're free to write dissenting opinions. It's not unusual for us to write dissenting opinions, Your Honor, or we don't get offended with that.
Yes, Justice Peralta, that we also learned that there was a case that you dissented, a more controversial case.
Yes, Your Honor.
What's your take on this question that, considering that jurisprudence are already settled, yet different decisions had been rendered by the Court of Appeals, then otherwise to be reversed by the Supreme Court? Is this a question of discretion?
No, I think, Your Honor, I beg to disagree. It is simply a difference of perception rather than abuse of perception. And perhaps the divergent views may be anchored on solid grounds too. Perhaps there is simply an invocation of one jurisprudence versus invocation of another jurisprudence by another colleague. Now, I think that would not be appropriate to label it as abuse because we are assumed to be acting within the parameters also of the presumption of regularity in the performance of official duty, unless there is evidence to the contrary. But we do respect of course, the ultimate arbiter is the Supreme Court. There might be some avenues which were not thoroughly considered by the appellate court, which triggered a different conclusion from the Supreme Court.
Is it all right if I may contribute something to that observation, that why is it that there are many cases that are being reversed by the Supreme Court? Is Your Honor referring to the drugs cases or all cases in general? Because
all cases.
because what we noted is that recently in the cases concerning drugs, because of that decision in People versus Romilim, where the Supreme Court highlighted the significance of judges, trial courts in general, of observing Section 21 of RA 9165. Because of that, there have been cases where the Court of Appeals used to sustain the trial courts in their findings of facts. Supreme Court, pursuant to that, had been reversing many of the Court of Appeals findings concerning this. And that is because of that shift of the Supreme Court to focus on Section 21. I think the Court now, Court of Appeals, has seen that trend, and Court of Appeals is calibrating its methodology of going over these drugs cases, which come from the trial courts, Your Honor. This is a response to the Supreme Court, I understand, from the fact that there is really a prevalence of many drug busts operations, which is good to arrest criminality, but at the same time, abuses have been reported. So this is the response of the Supreme Court, which the Court of Appeals and all trial courts should take guidance from.
Yes, Justice De Los Santos, do you agree with the further observation of Justice Bruselas?
Yes, Your Honor. I think those decisions were promulgated by the Court of Appeals prior to that decision by the Honorable Supreme Court. So much so that the interpretation then of Section 21 was different, I would say different, compared to the interpretation of the Honorable Supreme Court at present. So this is greatly affected by that. And we, most of us are really emphasizing more on, as long as there is preservation of the integrity of the evidence, there is no need to strictly comply with all the requirements of Section 21 or the chain of custody requirement. So now it would seem that with that decision of the Honorable Supreme Court, it is now more strict, and our decisions before are affected by that. So the reversal is not surprising, Your Honor. I agree with Justice Bruselas' observation. Thank you, Your Honor.
So therefore, Justice Peralta, could you synthesize the standing rules on compliance with Section 21, one of the Dangerous Drugs Act? This is in relation to the People versus Romilim.
There were 4 parameters which were made mandatory policy. In the dispositive portion, I think, through Justice Dado Peralta, in this case of People versus Romilim, he emphasized 4 points. Number 1, the sworn statement of the police officers should specify compliance with Section 21. Number 2, if there is no compliance, there must be a justification for non-compliance. Now, if ever, number 3, the case is filed before the fiscal's office, then the fiscal should exercise its prerogative of pursuing either PI, further PI, in Rule 112. Now, in the event the information is nonetheless filed by the Office of the City Prosecutor, this time the judge will exercise the prerogative of determining whether or not there is probable cause for the issuance of the warrant of arrest. So otherwise, if there is no basis for the further proceedings against the accused, the case should be dismissed according to People versus Romilim.
About in the case of People versus Visperas, was penned by Justice Del Castillo, with respect to the absence or presence of the essential witnesses.
According to some cases, the presence of the witnesses, the 3 or 2 witnesses, depending on the time frame of the commission of the crime, will have to be at the time of the seizure. Otherwise, there might be a fatal effect to the cause of the prosecution. But I also do remember the ponensya of Justice Tiham in the case of People versus Tripoli, to the effect that if that issue of Section 21 non-compliance was only aired on appeal, then that would amount to a waiver of any defect regarding Section 21 of RA 9165. Nonetheless, I am also aware of other jurisprudence that even though it was not raised on appeal, it can still be reviewed if there is doubt as to the identity of the corpus delicti.
About, sorry. Justice Badilles. How does the Supreme Court define the requirement of physical inventory and photograph of the illegal drugs immediately after seizure and confiscation?
Under Section 21, Your Honor, it is required that the arresting officers or the PDEA should immediately conduct an inventory of the items seized at the place of where the arrest was made or the bypass was made, and there should be a photograph taken, likewise of the items seized, and this must be in the presence of the taking of the inventory must be made in the presence of the elected public official and a member of the National Prosecution Service or media.
All right, thank you. That's all. Thank you, and good luck again.
Thank you, Your Honor.
Thank you.
Thank you very much, Judge Ilaw. Because I have already interviewed you before, I will just be brief. Listen to this, I will be asking questions from the four of you. According to Section 9, Rule 1110 of the Rules of Court, the aggravating circumstance must be stated in the information. Otherwise, it shall not be appreciated. Okay. In People versus Valdez, it was ruled that when the information did not sufficiently set forth the facts and circumstances described how the attending circumstance of the crime was committed, the accused cannot be convicted on the graver crime, such as murder. On the other hand, in People versus Batin, the allegation of an attending circumstance, such as treachery in the information, was ruled to be sufficient because the evidentiary facts need not be alleged in the information, and these are matters of defense. My question is, do you agree that when you say that an act has been committed with treachery, it is merely a conclusion? Justice Peralta.
Treachery, rather, Your Honor, is an acknowledged aggravating circumstance. Hence, I would like to believe that, as quoted by the good justice, Section 9 of Rule 110 is clear that this aggravating circumstance must be specifically alleged.
It must be specifically alleged, but should you specify the facts or the evidentiary facts?
Regarding the evidentiary matter as alluded to in the other.
In the information.
On the information, it need not be, I submit. It need not be specified.
Need not be. Justice De Los Santos.
Yes, Your Honor. Same question. I would say, Your Honor, that it is the right of the accused to be informed of the nature of the cause of the accusation against him, and that is under our Constitution. Now, as to whether or not it is enough to allege treachery without alleging certain facts in the information, that would depend as to how it is being described, why it constitutes treachery. Perhaps just the mere mention of treachery as an aggravating circumstance would not be enough, Your Honor.
So you have to expand to you have to specify the acts constituting
Yes,
treachery.
I believe, Your Honor, that treachery, because there are several forms of treachery, I believe that you have to express how that treachery as an aggravating circumstance was committed by the accused for him to be able to defend himself. Because again, as I've said, it is his constitutional right to be informed of the nature of the cause of the accusation against him, Your Honor.
Justice Bruselas, you are a former prosecutor.
Yes, Your Honor, please.
Oh, do you agree with Justice
Article
De
14.
Los Santos?
Yes, Article 14, Your Honor, enumerates the aggravating circumstances. And treachery is indeed, as mentioned by Justice Peralta, is an acknowledged, in fact, indicated, named, an aggravating circumstance, treachery. So that when you craft an information, and what is the information, when is it sufficient? The rules of court say it's sufficient when it is able to tell who the accused is, when the crime was committed, what crime was committed, and of course the aggravating or mitigating circumstances. There is no need to further expand what is meant by treachery because it will be in the nature of evidentiary facts. When the prosecutor now proceeds to present evidence on treachery, naturally and logically, he will have to tell the court, he will have to present evidence that will spell out precisely how treachery was committed. So if it is sufficient, if you are going to quash the information because it does not allege sufficient facts, because treachery was not explained, then that quashal should be denied because treachery is there. So I respectfully disagree with the Justice Edsa.
Justice Badeles, do you agree with Justice Bruselas?
I believe, Your Honor, that the information itself should be framed in such a way that some of the acts constituting treachery are mentioned in describing how the crime was committed. And for that reason, Your Honor, I believe that the mere fact that treachery is mentioned as an aggravating circumstance is not enough, Your Honor, because I believe that the body itself of the information can accommodate a description of how the crime was committed. And this includes the circumstances providing for treachery, Your Honor.
Okay, so you agree with Justice De Los Santos?
In a way, yes, Your Honor.
Okay. From Cebu and Mindanao versus Luzon Justices. In the recent case, N-Bank, this conflict was brought to the N-Bank in People versus Solar, and the Supreme Court on August 6 to 2019 settled the conflict, saying that it must be specifically described, including the acts included therein. Mere allegation of the word treachery is not sufficient. But don't worry, it is prospective, not like GCTA. This
Your Honor.
You have read the newspapers, only the newspapers. Can the President order the rearrest of released prisoners?
I think Your Honor already gave an answer that was asked by Justice Tiham.
I heard you.
I think, Your Honor, I would like to reiterate my answer that the President, again, being the power of control, being lodged with the President, and being the Chief Executive of our laws, it is within the powers of the President to order the rearrest of the accused, but I don't want to use the word arrest as issued by the courts of justice, Your Honor.
Use the word arrest.
Yeah, yes, Your Honor, but
You do not agree with the President using the word arrest?
if it is the term as used in our criminal procedure, I think that would really be appropriate because we have a definite definition of what an arrest means.
The President, you're changing your answer?
Because, Your Honor, because
You're changing your answer
the
now.
right to issue a warrant of arrest belongs to the courts of justice. And perhaps it was, I don't want to use the word that it was not the right term, but because the purpose there is, again, is to see to it that there should be a proper computation. There should be a correct computation as to whether they should really be granted good conduct time allowance. So,
Should not they be given due process of law? Should not they be heard first before rearrested?
no, again, if you may allow me, Your Honor, in that case of, in that good conduct time allowance law, it somewhat, I would say, modified the decision in the case of People versus Fideltan. Because with that law, it would seem that there is no more need for the court, because there is already a law passed by the legislature. Now, if that is allowed, that then I would rather repeat my answer that the president can order them returned to the for recomputation.
You're going back to your original answer.
Yes, because if
What is your comment here? Article 99. Such allowances, once granted, shall not be revoked.
yes, Your Honor.
Your understanding of that?
Again, as I've said, I think that that the provision is not constitutional, Your Honor, because if you say it cannot be revoked
Yes.
as pronounced by the legislature, it means that it
Not
forecloses the
favorable- Is that not favorable to the accused?
that, Your Honor.
Is that not favorable to the accused, that provision shall not be revoked?
Because that can be challenged before that can be brought before the Court of Justice, that particular provision, Your Honor.
But without any hearing, can the President order their rearrest, the released prisoners?
Now, again, as I've said, Your Honor, in that case of People versus Fideltan, there was no hearing required because
There was a finding that there was a wrong computation.
Yes.
Here, there is still no finding.
yes, because
Maintain the same answer.
again, I would say, Your Honor, that it has to be recomputed, and if there was correct computation, then they are entitled to go free. But
So it should be rearrest first, then release.
no,
Computed,
Your
right?
Honor, I think
Be the proper order.
because if what happened here is that it's not there should, when we issue a warrant of arrest, it's not there's a requirement of a hearing. There is a determination of probable cause. Then after the existence, the finding of probable cause, then the warrant of arrest will be issued by the court. Now, in this particular case, I would say that it's not it's a peculiar case, so much so that it's not the regular procedure that is being conducted with the court where a warrant of arrest will be issued.
There is no court proceeding. There is no court proceeding. When the President ordered the rearrest, there was no court proceeding.
No, okay. In that case, Your Honor, I would like to change my answer because that the President cannot just order them arrested. But if the intention is not really without using the word arrest, to make the report in order to give the Bucor officials to make a computation, I think it's within the power of the President again, because that decision of the Bucor can still be, say, subject to the powers of the President, or to the power of control, because the President, again, is the chief executive of our laws. So, not necessarily using the word arrest. Perhaps when it was used in a you can say it in a generic term.
Was
It's
there,
po-
was there an interpretation of that word arrest? Did the president, was the president not accurate in his mention of the word arrest?
Yeah, I think Your Honor, I have heard on TV that the word arrest was indeed mentioned, Your Honor.
Justice Badeles, what is your view? Do you agree with Justice De Los Santos?
I believe, Your Honor, that it is one of the duties of the President to see to it that the laws of the land are faithfully executed. Along this line, Your Honor, I would like to believe that the provisions of the rules of court on warrantless arrest may apply in the case of escapees from the penitentiary, Your Honor. You can make a case that these people...
Escape?
Yes, escapees, Your Honor. You can make a case that these people may be considered as escapees, Your Honor, considering that their release from jail was facilitated by the erroneous and mistaken computation of their GCTA.
Who said erroneous?
That is the allegation, Your Honor. Erroneous.
Allegation only?
Yes.
But
In
you
fact,
have
there
to
were
prove
allegations even of corruption, Your Honor.
You have to prove such
Exactly.
allegations before you can order the arrest? Or what?
There is
Why do you
allegation also, Your Honor,
Why do you consider them escapists?
because of the, as I said, Your Honor, erroneous and the mistaken computation of their GCTA, meaning that they were not entitled yet
Was there
to
a
be
review
released.
of the computation? Was there a review of the computation?
In some cases, Your Honor, I believe there have been, in the sensational cases, Your Honor, I think,
No,
that is why, Your Honor, they might be
Indeed,
considered,
there
as I said, Your Honor, they are considered as
was there a review of the
escapees.
sensational cases? Was there a review of the computation in the sensational
Not yet,
cases?
Your Honor.
Not yet, but
But as I
there is already a order of arrest.
Yes, Your Honor. So, in that light, Your Honor,
is
they
there
can
no
be
violation
ordered
of the
arrest.
Of the due process clause?
No, there is, because the,
Do they not have the right to be heard?
not initially, Your Honor. Eventually, yes. However, I
Then
believe
arrest
that
then.
their arrest is on the basis of the order issued by the trial court, Your Honor.
But the
After
trial
they
court
were-
has already lost jurisdiction
No, it's not. The court has not lost jurisdiction. It has
regarding
residual
execution.
jurisdiction to see to it that
it is
its
the
judgment are
administrative.
duly executed, Your Honor.
Oh,
The court
the
issued a mitimus order,
Yes.
a mitimus order directing that this convict be put inside the jail penitentiary to serve his sentence. It appears that he has not served his sentence completely. Therefore, on the basis of that order of the court,
If there is such a hearing before the court, assuming that that is covered by their residual jurisdiction.
yes, Your Honor, but
If there
not
is a
necessarily a hearing.
In the situation at
But
hand,
the question here
there
is
no-
whether the president can
yes,
order the rearrest.
their arrest.
Yes,
He did
on the
that.
basis, using as basis the order, the mitimus order issued by the courts, directing that
Was
this.
there a court order?
Yes, the mitimus order, Your Honor.
Was there a court order which the president used as a basis?
Perhaps none, Your Honor. He did not mention
None.
it.
Oh.
But we know that before these prisoners were confined in jail, there was a mitimus order directing their confinement in jail, Your Honor. And that confinement has not been complied with completely. That is why,
Let us listen
as I said,
to
it is the
Manila justices.
duty of the President to see
Justice
to it
Peralta.
that these laws are faithfully executed, Your Honor.
Sige, Justice Peralta.
To my recollection, Justice, within the constitutional sphere, it would seem that the verbal order of arrest of the President might transgress the due process clause, because it's clear from Section 1. It would amount to a deprivation of liberty without due process of law. Now, secondly, the problem of the prospect of apprehending an individual who is already out there pursuant to the what appeared to be an erroneous release order or erroneous computation of the GCTA. And I cannot, however, equate the verbal order of arrest as akin to Section 5 of Rule 113 because this Section 5 presupposes an escapee. And this fellow is out there already pursuant to the GCTA is not, to my mind, an escapee. Now, on the other hand...
You accord the presumption of regularity in the computation.
Regarding the presumption of regularity, we as public officers are entitled to this presumption of regularity. Now, I'd like to follow the line of thinking expressed by Department of the Office of the President regarding the phrase Article 99 of the Revised Penal Code as amended by RA 10592 because it would seem that the premise of the department was that it was not lawfully justified because there was an erroneous computation. Hence, to the perspective of the DOJ, if I may say so, and if my reading is correct, and if my hearing was correct, it was simply a continuation of the service of the sentence. And the President, I think, was just implementing the verdict as promulgated by the Courts of Justice. So perhaps I just do not know what is in the mind of the good secretary regarding
I'm just
this.
asking all of you your opinions only.
Yes,
We
Your
do
Honor.
not know all the facts. But,
Yes, Your Honor. But
so-
I would like to think, perhaps only, Your Honor, the good secretary was thinking about the residual power of the President under the revised administrative code, which can serve as the possible legal foundation for the implementation of this verbal order of arrest.
Justice Bruselas, you agree with your
The framework, Your Honor, should be Article 3, Sections 1 and 2. That's the framework in looking at these facts. What is the framework? It's already mentioned. No person shall be deprived of life, liberty, or property without due process of law, nor shall any person be denied the equal protection of the law. The second part there is, no search warrant or warrant of arrest shall issue except upon probable cause to be determined personally by a judge after examining under oath the complainant and his witnesses, particularly describing the place or things, persons to be seized. I think that's the framework. So if you look at the facts, given facts, based on this constitutional framework, there would seem, just an opinion, Your Honor, there would seem to be an error somewhere there. But let us also look at the fact that the President is the chief executor of the law. And what has happened was there was a mass release of prisoners, allegedly even prisoners who are excluded by the good conduct time allowance as amended. Who are these? Recidivists, habitual delinquents, those who have been penalized for heinous crimes, and escapees. Now, that is the background of, now why did the President act? Because thousands have been released. And there is a remedy, of course, judicial route, which will take one by one each individual. I think the workaround here is what the President said. Now, this may exactly not be, mention was made of Rule 113, no? Citizen's arrest. When the President said, declares, you have 15 days to surrender. So, they are not escapees, but after the 15-day period that is declared publicly by the Chief Executive, that they ought to turn themselves in because of so-called erroneous computation or errors, and they fail to obey the 15-day period, then perhaps that is the time when they may be considered escapees, and probably...
You make such determination at the end of the period.
That's why, Your Honor, the President has made that period, and who made that determination? It is by operation of law, because if there is no legal if you have not been allowed to go out and you still remain to be out, then you are by in effect an escapee. Just a workaround. I am not so sure, but I am saying, Your Honor, that firsthand, we should look at the Constitution, and apparently that is not the very good way of doing it. But we have to understand also the nature of the case, that there are thousands out there who should not have been released because they are not qualified to be released. And the President has acted. Of course, eventually the courts will have to determine this. Thank you very much.
If I may allow, Your Honor, just one brief observation.
It's
Now,
amazing.
because with
you kept changing.
permission, Your Honor, because it was mentioned that there might be a denial of due process on the part of those convicts. Perhaps it may be appropriate also to mention that, as what Justice Cardoso said, due process is not only due to the accused, but also to the accuser. So due process is also due to the state. So I don't think it is absolutely wrong on the part of the President also. Due process is also due to the accuser of the state. Thank you, Your Honor.
Thank you also. Oh, last topic, you are all justices of the Court of Appeals. You know very well that decisions of the Ombudsman in administrative cases are reviewed by your office. You know that? Oh. Yes, Rule 43. Oh, even Justice Badelleles is a case. Oh. Now, these are the facts. Representative Jose, a former governor, was found guilty of grave misconduct by the Office of the Ombudsman. The case stemmed from an unauthorized contract that he entered into when he was still serving as a governor. As such, the Office of the Ombudsman ordered his dismissal from the service. The said dismissal order carried with it the accessory penalties of perpetual disqualification from holding public office, cancellation of eligibility, and forfeiture of retirement benefits. Congressman Jose moved for reconsideration of the said ruling, but the Office of the Ombudsman denied the same. On motion, the Office of the Ombudsman ordered the Speaker of the House of the Representatives to enforce the dismissal order against Congressman Jose. The Speaker refused, arguing that under the 1987 Constitution, there is nothing among its provisions that authorizes the Ombudsman to discipline any member of Congress. Now the question is, can the order of dismissal by the Office of the Ombudsman be implemented against Congressman Jose for an offense that he committed during his incumbency as a local official? Justice Badelleles.
There are two issues here, Your Honor, that would appear to me as relevant. One is the condonation doctrine. Having been re-elected by the same constituents who elected him as governor before, and now he is elected as congressman, then by the application of that doctrine, Your Honor, the condonation doctrine, then he should be exonerated. Second, Your Honor, on the power of the Ombudsman to direct the Speaker to dismiss the member of the House of Representatives, I believe it is very clear that only the House of Representatives have the power to determine the qualification and the who may become members of the House of Representatives, and any intrusion into this, Your Honor, would be not allowed, Your Honor.
Justice De Los Santos.
Your Honor, I am in a quandary as to whether or not I will answer that question, because although it is a hypothetical case, there is a case that we decided in Cebu where the ponente issued, I think, a 23-page decision and I submitted a separate concurring opinion consisting of 21 pages. So I don't know whether I am supposed to inhibit or I have to answer that question. But if I'll be required to answer that question, because that case is now before this...
We will not take it against you.
Okay, Your Honor. I will stick to my opinion, Your Honor, that I have to apply the condonation doctrine. So the Congressman Jose should be allowed, in this case, absolved from that. He should be allowed to run, something like that. But as to the other issue, as to whether or not it can be enforced by the decision of the Ombudsman can be enforced by the House of Representatives, I agree with Justice Badelles. It is not within the powers of the Office of the Ombudsman to encroach on the powers of Congress to discipline its members. I think it's beyond the powers of the Ombudsman to encroach on the powers of of Congress to discipline its own members. Perhaps what we need is a cure that will be done through legislation, Your Honor, regarding that. But as of now, there might be, shall we say, there might be some, I don't want to use the word controversy. There is an apparent conflict as to the powers of the Ombudsman to compel a member of the House of Representatives to obey its decision. So we'll stick to that, Your Honor.
Justice Peralta, without giving any reason, do you agree with the opinions of the two justices?
Yes, I agree.
So you agree.
Both
Suppose Congressman Jose ran in a different province. Would your answer be the same?
Regarding this situation, I would still agree with them.
Is he covered by the condonation doctrine if he runs in another province?
I think the condonation doctrine can still be appreciated even though it has reference to a different elective post, provided he meets the qualifications for that particular area where he transferred under the Constitution.
Justice Bruselas?
I think the key there is the body politic. Is it the same body politic as held in the Supreme Court, penned by, I think, the Honorable Justice Mendoza in the case of, I think, Vergara or Templo Año Nuevo? That for so long as the same body politic elected the official who had been administratively held liable by the Ombudsman, and he runs for either a governor.
He ran in a different province.
Oh, if it's in different province, precisely, that will not apply because it's a different body politic. We're talking about the Congress, a governor.
So you do not agree with Justice Peralta?
With due respect, it is to me, Your Honor, with due respect, it does not squarely apply the condonation doctrine to that position, especially now prospectively, in light of Binay, where the court held that beginning November 2015, that condonation doctrine, which was started in Pascual versus Province of Ecija and Aguinaldo versus Santos, is no longer good law. But we can apply that in limited cases only, retroactively, very limited cases.
The rule now is that you should be re-elected by the same constituent body. That is the rule. Same body politics, the same. Thank you very much, Justices.
Thank you very much, Your Honor.
Thank you very much, Your Honors.
Oh, you want to Pagod na rin ako. Daming excuse.
Thank you very much, Honorable Justices of the Court of Appeals, and we wish you all the best of luck. So that concludes today's proceedings. We still have 15 more candidates to be interviewed tomorrow and on Wednesday.
Sakit ng ulo.